again, it comes back to reasonable endeavours, done your best. Any questions?
Fantastic. I've got a question that I bet is relevant to 95% of people in the room with. The first thing I found out is that my secret dossier on Paul's personal life is probably illegal, and I certainly shouldn't be selling it online. My question... Mine is a sort of fix-it question, and I bet this is virtually every business in the room. We all hold data on past and current customers, first one. Second one is people who've inquired about the product but never took it up. And the third one is data what you've acquired that you can't quite remember how. Bits of database, all legacy stuff and all that kind of thing. And what you don't want to do is ditch all that. So is there a kind of fix-it way where you can recontact all those people and allow them to opt in, or even better, the soft opt out?
We're talking about sending them emails.
You know, we've all got this data. How do we kind of bring ourselves up to some level of compliance without scrapping the whole thing and kind of ruining the contacts that we've got?
I mean, bear in mind that we've had our own marketing people have had this issue with us, that it actually, this all applies to email marketing, but doesn't actually apply to any other kind of marketing. So, for example, our marketing people have got a whole load of email addresses, and they're saying to me, well, we've got their email addresses, we've gained it in the course of business, can we just email them? Well, no, you can't. But what you can do is ring them up or send them a letter, which is what we end up doing, and saying, you know, we've got your email address, or can we have your email address? You know, used to deal with you, have a chat with them, whatever.
So it's like a classic cleansing exercise. Go and recontact and then establish.
I would always say it's best because that way you get, it's going the consent route. I mean, getting the consent is always preferable.
How do they give you that consent? If you ring them up or you send them a letter, how are you going to physically get proof of that consent back?
I think if you ring them up and they
record it.
I wouldn't go as far. I don't think you don't
tap the phone.
I mean, you don't need to go as far as I don't think to record a conversation. And indeed, I wouldn't recommend that at all. How I dealt with that actually previous place I worked was just make a note of the conversation. If the person says they're quite happy to receive it, just make a note, date, you know, for your own file, date and time of the conversation. Spoke to so and so, they confirm they're happy to receive it. Have it on the file. Maybe have your first email with it as per our conversation. You confirmed you're happy to receive. Here's the first one. Have an opt out on that.
Right.
That's fine.
Question.
You were far wrong with
that. You mentioned very briefly earlier on that different countries obviously have different strengths of data protection regulation. If you were sending out emails that you were using a firm in America to distribute those emails, which would necessarily mean you have to upload your distribution list onto their machines or hardware. Is there a problem with that?
Depends what you're sending. Yes, potentially. If you're sending personal data, so names of people, details of people, well, you can identify that person.
Well, you'd be sending, I suppose, their name and their email.
Potentially, because of course an email address could be personal data, because the definition under the Data Protection Act, the definition of personal data is simply data from which an individual can be identified. So if you can identify an
to my knowledge, the top 5 in the UK legitimate email bodies are all US based. They're not, but they are known as whitelisted, so Stanford don't like them.
Does that make a difference? Because you call them whitelisted?
Yeah, there are various different lists. I mean, Safe Harbour's one, for example, where there are certain, basically, certain companies or states in America, whatever, have agreed that they will comply with a certain level of data protection regulation. That's all been approved and ticked off, and therefore you get onto a certain list, and that's deemed to be compliant with the level of data protection law in this country. The problem,
that would be okay.
Yeah, it's okay. The problem in America is that America as a country doesn't have any data protection law at all. So unless wherever it's going in America is signed up to one of these lists, then potentially you're in breach of Data Protection Act, because you're just exporting it to somewhere where that protection for the individual isn't in place.
I think it raises the question, and we never did it when we started doing it in November. We only go with who we use because graphically it was easiest to do.
Yeah.
You know, as far as that might sound. No, I know that it does comply, so I believe it does. But how would you, if you were starting out today, say, right, I'm going to start doing email marketing, be a third party? How do you know where to go that complies? So I've never come across that.
You mean in sending it out of the country?
Yeah. usually some in the States, we do. Now, it just happens to be that they do comply.
Yeah.
It looks like, but we didn't know that when we started looking in there.
No.
How would you know?
There are. I've got a list, so I don't have it with me, but there are lists of websites that you can go to, which if you want them, I can probably dig them out for you. Which actually list all these organisations and what's on what list and that kind of stuff. But again, how would you know that? With great difficulty is the answer. You wouldn't. Yeah.
The previous email marketing courses I've been on, they never talked about it.
Yeah.
In ignorance, nobody else.
Yeah.
I've done the next one.
Yeah. I've done it.
If the firm in the States say that they comply, say, with EC or EU regulations, if they say that, is that enough? I mean.
No, I would want a little bit more. I would want. Okay, if they say that, well, fine. What list are they on, and what do they comply with? Then just check it. Because ultimately, it's coming back to you. If you're sending an email out, you're the guy on the hook at the end of the day. So, how much comfort do you need? I suppose is the answer.
Now, but I think what probably is best if I come back and do a separate talk another night, purely because I can talk about IP for an hour on its own, and I couldn't do it justice or answer specific questions because I know a few people have got a few problems in here. So I'm more than happy to not problems and IP problems, I should have said maybe.
It's taken 40 minutes to figure us out.
Could you say anything about whether you have any rights for what you write on a website, or if you have nothing?
You do. It basically, what's on a website is protected by copyright mainly. You'll also have the designs in there that may be protected by design right, but generally 2D images and writing is copyright only. But there are specific things that you have to achieve before you get copyright protection. So, for example, it must be original. It can't be copied. The author of it has to be resident in a certain state or a certain country, so the UK, that sort of thing. So there's lots of hurdles that you have to get over. But exactly, well, I think that's what I need to come back and give you. I think that's what I need to do, because I'd just rush it and miss out big bits for you. And I think you need to know the basics.
Is there any way you can find out if people are copying?
There are companies that do watches on websites. They mainly do watches on trademarks, if I'm honest. I don't think there's really anything around that you can look at to assess whether or not.
Practical way, into Google, put it in speech marks, big finger text, see where it comes
Look
from.
in your competitors' websites as well, because they're generally the people that are going to try and take advantage of your goodwill and what you're writing, especially if you're selling similar products. If they like what you've written, they'll try and adapt it. There may be copying there. It's all about whether or not there's been substantial copying, but it's just too complicated for me to go into for you now. I think if I went into it now, I'd confuse you rather than help you. So I'm more than happy to set a date to come in, or you can always give me a call at work and I can answer any questions you've got. But I think I need to come back.
Fantastic.
Not by email, though.
Food in, over here.